All right, welcome everyone, single file. Come on in. Zoom bombers not allowed.
People actually showed up for this.
Uh-oh, here's someone who's a troll.
Oh, I'm sorry, that's my daughter's profile. Sorry.
The first Zoom bomber?
First one.
Oh, I assure you I'm not. Hey, Eric.
Hey, how you
The
doing?
first G-rated Zoom bomber.
Yeah, right? I'm going to stop everyone's video other than me and Jeff. All right, let's get some more folks in here. Hopefully this works. Don't want anyone sharing their video. Just me and Jeff. Welcome, everyone.
Hey, everyone.
All right. Oh, here's someone. A couple folks. I'm going to turn your video off. If you try and turn your video on, I'm going to turn it off. That's why I hate Zoom. That's why I like Facebook better, but that's okay. All right, folks. Welcome, everyone, to this Friday edition of, well, it's not the Employer Handbook Facebook Live. It's the Employer Handbook Zoom edition. The Employer Handbook, maybe unofficially FMLA Insights collab. This handsome gentleman who's joining me, maybe you've heard of him. This is Jeffrey Nowak. Jeff is the publisher of FMLA Insights, FMLAinsights.com, and he is a shareholder at Littler Mendelson. My name is Eric Meyer. I am a partner in the employment practice group at Fisher Broyles, and I publish the Employer Handbook, employerhandbook.com. Jeff, did I cover the, did I get the script right?
Yeah, I think so. So far, so good.
All right. So far, so good. And pardon me, folks, if I appear distracted. I've set up as many possible prophylactic steps as possible to avoid Zoom bombing today. And I know we have a big registration list. So if I seem distracted, it's because I'm admitting people from the waiting room and that showed up late, but all right. Let's get started.
Is there a way, Eric, for you to turn off my camera? I mean, look, I need a haircut. I haven't gotten a haircut in 2 months. It's like I'm flying around the house because I've got wings on the side of my head. I'm just flying around. I shower once a week, eating Twinkies nonstop. This is ridiculous.
Have you thought about giving yourself a coronavirus haircut? Because I've looked at YouTube videos. I've been thinking about it.
I've even asked the family who wants to shave my head. And they're scared. They're scared to shave my head. What, they're worried about my reaction or something, or what?
Going full shave. Nice. Nice.
It's summer months.
All right.
Great to be with you all.
Yeah, it's great to have you. Thank you, everyone, for showing up. Just a reminder, please keep your video off. Keep your mics muted. Jeff and I are the only ones who are supposed to be talking. If we do this right, if we do it wrong, oh gosh. This is getting recorded, so maybe I can't upload it to YouTube. Let's do a quick disclaimer. So Jeff and I are employment lawyers, right? But we're not your employment lawyers. And even if we technically are your employment lawyers, like even if some clients snuck in, shame on you. That's okay. You can be here too. We're not giving legal advice, and we're not creating any sort of attorney-client privilege. You know, this is a free Zoom 1 hour session, right? If you rely upon this for your legal advice, shame on you. Go pay your lawyer for that. That's what they're there for, all right? Not us. We're answering hypothetical questions that we assume you're asking for a friend. We have a list of those questions already. Please feel free to add those questions in the chat box, right? So there's a little chat feature down there. We've kept that turned on. Please keep it PG. Let's see what's going on in the chat box. Hey, Robin. Hello from Ohio. Hello. Oh, Elaine wants to know when I shaved. It was the other day. Thanks for noticing. Jeff Nowak rocks. Yeah, he does. In Madeira. And hello from San Francisco and sunny. All right. we've got a bit of an agenda today. You didn't come here to see us joke around. We're talking about the classic. We're talking about the OG FMLA. It's really been getting short shrift over the past couple weeks. Everything's been FFCRA, PPP, OSHA. What happened to good old FMLA? So first thing we wanted to do is talk a little bit about some of the overlap between the FMLA and the FFCRA, and maybe some of the distinctions as well. And I'll toss this out to Jeff to just rehash what basically we already know. FMLA and FFCRA, a little bit of a distinction there in which employers are covered, and then also which employees can take leave. Do you want to give everyone just an elevator speech on that? In case they...
Sure, yeah, and most of us are aware of this. Unlike the classic FMLA, FFCRA, whether we're talking paid sick leave, paid FMLA, fewer than 500 employees. And that's company-wide. This isn't the 50, 75-mile rule. That's out the window. At this point, we're looking at those employers fewer than 500. There are some quirky rules when it comes to integrated employer. If you're a corporation and you've got sister companies, you've got subsidiaries, talk to your attorney, because that is a potential mess with some legal ramifications depending on how you approach that topic. But we're talking about smaller than 500 employees, eligible employees, two different eligibility rules. Paid sick leave, you're eligible day one. You walk in the door, you are eligible for paid sick leave. Paid FMLA, which of course only covers caring for your child whose school is closed or childcare is unavailable. There we're talking 30 days of employment. That's on the payroll. So if you go on leave for whatever reason during that time, let's assume you're employed, you are now the employee, but let's say you go on some kind of leave of absence, or you're otherwise not working. Because you are on the payroll, that would count toward your service time. Now, other rules may get in the way in terms of furloughs and stuff like that, in terms of your entitlement to leave, but you would be eligible 30 days of employment.
And
Make sense?
Jeff has a post up today. I saw it on LinkedIn. I assume it's on your blog as well, about the new DOL, relatively new DOL FFCRA frequently asked questions update that gets into temporary employees. So what if you work for a temping agency that has over 500 employees and you're placed with a company that has fewer than 500 employees? We're not going to debate that here, but I would encourage you to check out Jeff's blog for that answer, FMLAinsights.com. And hey, if you haven't connected with Jeff yet on LinkedIn, I'm sure he'd love to connect with you there too. So you can find those answers as well.
That's a really good point, Eric. In terms of temp employees, you are counting them. You're counting temp employees as well. But those crazy little rascals at the DOL, they've thrown us for a loop on some of these FAQs. And thanks for the shout out on my blog post today, where I talk about temp employees. If you're an employer and you use temp employees, take a look at my blog post today, because they're FAQ 90, if you care about it. FAQ 90 offers kind of some a quirky way at who's on the hook for paying temp employees. Got to be careful about that.
Yep. Yeah, exactly. Someone asked a question going into this what do we call it? Zoominar, webinar? I don't know. Chat. A pretty basic question. Which of the 6 emergency paid sick leave reasons count towards FMLA?
You want to tackle that or
Sure.
me?
I mean, on its face, we got one of them that's going to count, and that's the emergency family medical leave. So if you have a child who is home from school, pretty much everyone who has a young child is home from school. because the school is closed due to coronavirus-related reasons, or if the child is in a daycare and the daycare is closed, that EFML, which is also reason number 5 for the EPSL leave, that counts towards the Family Medical Leave Act. So that's the one overlap. However, right, on its face, take leave for coronavirus or coronavirus-like symptoms, leave reason number 2 for EPSL, doesn't invoke the FMLA. But I think it's pretty fair to say that in most situations, when you get diagnosed as having coronavirus, you visit a doctor, you're under ongoing treatment, you're probably going to have a serious health condition as well. So those would be situations in which, you may get that EPSL leave, but you're also covered under the Family Medical Leave Act. Same deal if you're taking care of someone who has coronavirus or coronavirus-related symptoms, leave reason number 4. So there's not intentional overlap, but there could be inevitable overlap for some of the EPSL reasons.
Yeah, and I think we're forgetting about those potential situations. We think of paid FMLA leave as caring for the child because the school is closed. We're thinking of it as the child care part of the FMLA, at least through this December. But there are a whole host, and you've pointed out several of them, where the classic FMLA might apply. So, someone who is diagnosed, who has a positive COVID test, that is unable to work, you've got continuing treatment with a healthcare provider, that is likely to meet all of the requirements of classic FMLA, and it's going to run that FMLA clock. What about a situation where an employee says, I want to stay home because I have an autoimmune disease, I have asthma, I have a health condition that will be exacerbated, or I will be susceptible to COVID-19 as a result? Or what about an employee who says, I have a family member with a condition, an underlying medical condition, and they want me to be home, or I want to be home because being at work put me at risk and therefore them at risk. So what are your thoughts? Toss it back at you, Eric, or I'm happy to talk about it. What do you think about those situations? What are you looking for?
Well, it's a little bit of a dance. Whoever Martel is, I'm going to, bear with me 1 second. Martel.
Here.
Hi, Martel. Would you be
How
able
are you?
to take your video off?
Yes.
Thank you, Martel.
And mute as well? Everyone mute their
Yeah,
line?
there you go. Thank you, Marcel. So in that situation, Marcel. Sorry about this, folks. Sorry. Bye, Marcel. Marcel's been removed. Oh. So in that situation, well, we get into like documentation certification issues, I think, because on the one hand, the requirements for getting the EPSL leave are rather light, right? So if you want to get leave because you have COVID-19 symptoms, or you're taking care of someone who has COVID-19 symptoms, all you have to do really is put down your name, put down the name of the person who it is, and their relationship to you, and put down the name of the healthcare provider. That's pretty much it. You're going to get some EPSL leave. But for that next step, in order to get the FMLA leave, then we go through the regular old FMLA process of, you put the employer on notice, the employer is going to give you a notice of rights, you're going to get that FMLA certification filled out. then it's going to get sent back, and the employer is going to make the call as to whether you're eligible for FMLA leave. So documentation and certification, more formalized and a little bit more rigid under the FMLA, but there is that, you can get both. Now, the other thing too, we haven't talked about it yet, it's later on in the agenda, but why not talk about it now, is the Americans with Disabilities Act. Now, you're not going to be able to, let's say, take leave to care for a loved one under the Americans with Disabilities Act, because the ADA only covers the individual employee, him or herself, that has the disability. But if you yourself have COVID-19, which the the EEOC has kind of said it depends whether, is that a disability? And they kind of punted and said it depends. But potentially that could be a situation in which you would need a reasonable accommodation, which theoretically could be FMLA leave, theoretically could be some other form of leave. So, there's a lot of balls to juggle there. Jeff, what I leave out?
Yeah, I think the what a number of my clients are struggling with is the employee that is worried about being at work, maybe because they have a health condition. I just spent time yesterday with a client who has an employee who has requested leave from work simply because the family member has requested that the employee stay home, not expose themselves to whatever might be at work, because the family member has an underlying health condition. And we need to tread carefully. The DOL hasn't spoken explicitly on this topic. They issued it's not an FAQ, but in some of their initial guidance, they suggested that an employee can't take FMLA leave, can't take FFCRA leave, and therefore FMLA leave, if they are worried about being infected with COVID-19. So the same would hold true that if they're just worried about infecting a family member back at home, I don't think that's going to be enough to trigger whether it's paid leave or whether it's classic FMLA leave. But I could see an instance where this could quickly convert to an FMLA situation. For those of you who have followed my blog or have heard my presentations before, I harp a bit on the Santiago case. The Santiago case is kind of applicable here in this situation. A case from a number of years back, federal court in Connecticut, where the employee had cluster headaches. And the doctor said, this employee cannot work during the winter months because the conditions in the salt house, he worked for the Department of Transportation, where he worked would exacerbate his condition. And so he would need leave, he couldn't work overtime during that period of time. And there the court said if the health care provider requires that person to be off as a prophylactic measure, then that triggers the FMLA. So it's and that comes right out of the regulations. You may be familiar with the portion of the regs that talk about the person with asthma, that a doctor may put them off work when the pollen count is too high because they're worried about exacerbating their asthma. So I do worry about that Santiago kind of situation popping up here, where if you've got an employee with documentation in hand, to Eric's point, those first 2 weeks, that deference to the employee, because there's very little documentation that's required, as we know. But once we get into the land of FMLA, which would closely follow, now I'm looking for something more. I'm looking for actual documentation from a physician. I don't need the employee's word for it. I don't necessarily want the employee's word for it. But I, as an employer, I can require that the documentation establish that the employee needs to be off work. The same thing for caring for a family member, simply because they may have a medical condition. it doesn't necessarily mean that they're incapacitated and therefore your employee has to care for them. But once they provide documentation that creates that link, I think we're in a tougher spot to deny leave in those instances.
Yeah, it just to make clear to the audience, and I think we've made it clear already, but just to underscore it, you don't need to provide written documentation as a prerequisite to get the FFCRA or really the unforeseen FMLA, right? So verbal notice is enough, but for FFCRA purposes, really for the IRS's purposes and your purposes for getting the tax credit, you do want some sort of documentation to substantiate the tax credit. For FMLA purposes, well, we just know that, under ordinary circumstances, you want the serious health condition to be certified so that it's FMLA qualifying and so on and so forth.
In terms of one more thing on documentation, since we're talking documentation, what about telemedicine visits? So all of tons of employees, that's the mode of meeting with their physician right now, right? They're jumping on the computer. They're getting on a phone. I had an appointment, just a checkup appointment with my physician. Just did it by phone. Very convenient, no big deal. We checked in. Maybe he or she could provide me a doctor's note to confirm that. Is that acceptable? And that's been, there has been a little bit of a tug of war, at least in the classic FMLA space prior to COVID-19. Do we accept telemedicine visits, online visits with the doc to support the need for FMLA leave? So, a couple of things on that point. Number one, keep in mind that you never need certification to designate FMLA leave. You absolutely can require it as part of the FMLA, but you don't have to have it. So particularly in situations where the employee is unable to work because of a serious health condition, you can designate that time without necessarily having a medical certification. Now, do I recommend that you have it? Yes. I certainly recommend it as a best practice. But when we're in the middle of this pandemic now, where the EEOC, the DOL have told us, hey, take it easy on your employees, and let's not insist on doctor's notes in every situation. I think this is high time where we, at a minimum, start accepting telemedicine visits to support the need for leave in these situations. And to the extent that you require documentation, make sure that you're giving your employees additional time to provide that documentation without before you hit the denial button, before you hit the termination button. In terms of kind of where I'm drawing the line on documentation, if you've got an employee with a positive COVID-19 test and they've been off work, I'm not going to fault you for wanting some kind of documentation. You want to ensure that your workplace is safe. You want to ensure the doctor is signed off on them coming back to work. But if without a positive test, I'd much more rely on symptoms. What are your symptoms? And following the CDC guidance in terms of how long you keep someone off work symptom-free, and giving them that additional time to, if you insist on documentation, making sure that you're giving them plenty of time to provide that documentation.
Yeah, Jeff, you raise a good point. Maybe it's not so much at the outset that the documentation is the big deal, but fitness for duty, returning to work. I want to see something, especially if they've been diagnosed. I want to see something from a doctor that says that this person is safe to come back.
Yeah.
Because, you want to see, I forget what the latest guidance is, 7 days COVID-19 symptom-free or 10 days, whatever it is. People don't, not everyone is cured within 10 or 14 days. So I want to see something from a doctor that says that this person can come back into the workplace for sure. Just a general question for you. We don't really have to dwell on it. Anecdotally, are your clients or people you're talking to, are they providing the intermittent leave under the FFCRA, or are a lot of them saying, we don't have to, we're not going to?
I think employers, what I'm generally finding they're being pretty flexible on the need for leave. There is definitely a give and take, at least an attempt at a give and take with respect to childcare issues. So a lot of discussions going on between employers and employees right now, where the employee has to care for a kid at home because right now, of course, school is closed. So they're all working on remote learning. They're helping their kids with their remote learning, and they can't give you the typical 8 to 5 or 8 to 6, 9 to 5, whatever it might be, job. So I'm pressing on my clients. I'm encouraging employers to work with your employees. Heck, the DOL and its FAQs all over the place says work with your employees. It should work for both sides. So that's how I'm approaching the conversation. I'd encourage employers to do the same. That, look, we want to help you in any way we can. We know that this is a difficult time. Let's try to work out a schedule that allows you to care for your kids because they're home from school or childcare, but also allows you to do your job. And if that means flexibility in terms of when that's done, do it. I'm encouraging them in any and every instance to do that. And I think the childcare issues that we're seeing now, and we're going to continue to see it. Once summer hits and school is out, now I anticipate I'm going to get plenty more calls from employers wondering, well, now school's out, do I have to keep providing them leave for childcare now?
Yes, you do.
Yeah. So, that'll raise a whole host of questions, but, really important to try to find a balance with your employee. But keep in mind too, that the regs and some of these FAQs, they're employee friendly on the issue of childcare, of the right to take FFCRA leave to care for the child whose school is closed or childcare is unavailable. So tread carefully there.
Not so friendly on the intermittent leave for the other reasons,
right?
Especially if you're, working. The distinction between work and telework. As the employer, even under the FMLA, you don't want to give someone intermittent leave. You don't necessarily want to give someone intermittent leave who's going to be coming in and out of the workplace if they have COVID-19.
Right.
And the DOL calls that out for the EPSL reasons. If they're working, no, there's no intermittent leave there. But if someone's teleworking, let's say they're taking care of someone with COVID-19, then you can provide them with intermittent leave under the FFCRA, and you should provide them with intermittent leave under the FMLA if that COVID-19 is a serious health condition, and so on and so forth.
Right.
All right. I think we've exhausted. Oh, actually, no, I have one other question. FMLA and EFMLA, taking it concurrently. So let's assume that I have a spouse with COVID-19 and I'm caring for a child who's home from school. I assume I don't think the DOL has come out and said this definitively, but I assume if you can get all that done in 12 weeks, knock yourself out, right? Sorry for you. But you certainly don't get 24 weeks to do that. Would you agree with me?
Yeah, I agree. And keep in mind too that it doesn't, this is going to be an unusual situation, but in terms of the paid leave portion here under FFCRA, the time travels with you. So it's per person, it's not per employer. So it's not as though I can take 12 weeks off from one employer and then jump to another employer in September or October. Although, wouldn't that be sweet, Eric, if someone actually could do that? But there is a limit. It's per person. It's not as though you can jump. But how do you confirm that? You're essentially on the honor system, right? You're going to call up the old employer. Hey, did this guy take FFCRA? Presents a dilemma, but it is per person.
I know some clients that would. I know some clients that would call. This is a good segue into PPP, which I'm going to discuss a little bit. And I quipped when I was promoting this event, is there some sort of overlap between FMLA and PPP? And I think there is. And I'm talking about the Paycheck Protection Program. That's the one where everyone jumped to get those loans, multi-million-dollar loans, or maybe a couple $100,000 loans. And all of a sudden, we're told that we have to spend 75% of that money within 8 weeks of receiving it on payroll. But here's the thing. Payroll is a pretty broad definition, and that includes benefits. Now, it doesn't include the FFCRA benefits, okay, the EPSL leave and the EFMLA leave. That would be a double dip because you're getting a tax credit for that already. But if someone's got some paid time off in the bank, right, that you would otherwise run concurrently with FMLA leave, okay, let's assume someone is out for COVID-19 reasons. Let's assume they're out for more than 2 weeks, so they've burned through all their EPSL. We are in pure FMLA territory, nothing else. That's a situation in which you could use some of that PPP money, right, to pay for that paid time off that the person is taking currently with what would otherwise be unpaid FMLA. You can also use PPP money for employee benefits. So, when someone goes out on FMLA, you keep their benefits intact. They're responsible maybe for paying their own employee portion, but you can use the PPP money to continue to pay for their benefits. So there are some situations in which there is an overlap between PPP and FMLA. I came up with something. It works. But here's one that I'm going to take it maybe a little bit away from PPP, although this is more a generic issue, right? Someone goes out, someone is making, I don't know, Jeff, they've been with the company for a couple years, so they're an eligible employee, they've got the 1250, they got the 1 year, they work at a location, 50 employees within 75 months. They want to take FMLA. Maybe it's related to COVID-19, maybe it's not. FMLA is unpaid leave. But they see that some of their friends who have been laid off, unfortunately, are fortunately for them collecting more on unemployment right now. Can you ask your employer, or as the employer, can you work out a deal with your employee who would otherwise take FMLA leave to put them on furlough so they can get unemployment compensation? Thoughts?
I've got to think that there are some fraud provisions in the various state unemployment comp statutes that might stand in the way of that. It does present an interesting dilemma, though, doesn't it?
Yeah, it does.
Because when you're on furlough status, under, I think, all of the unemployment comp statutes, you're going to get comp. You're gonna get that money plus the $600 kicker from the feds. Mm-hmm. And if you are on leave, from work, FMLA, FFCRA, you're not going to be entitled to unemployment comp. I mean, that certainly wouldn't be my counsel, that you're working out that arrangement with your employee. But I suppose it's an option that's out there for the particularly generous employer that wants to say, look, I'll put you on a furlough status for a period of time until I need you. There might be some flexibility in doing that. That would seem to be an option.
Yeah, I mean, a couple things about that. Like, if you have COVID-19, I mean, one of the things you have to certify is, in most states, is that you're ready, willing, and able to work. So most states have, I think, relaxed those rules right now if you're unemployed and have COVID-19, but your mileage is going to vary. The other thing, too, and I think of the Escriba case, if you opt to take a furlough instead of FMLA leave, right, one thing you don't have is job restoration rights that would otherwise be available under the FMLA. So, when furlough time is up, maybe in the interim, the employer has realized, you know what? We're a lot more efficient without old Eric Meyer around. You know, I don't have any job restoration.
Not hard to find. Yeah.
Yeah. Stop. Stop. I must be a key employee. I can't.
That's right. Fisher Bros would be nothing without you.
Right. So.
No, you raise a really good point. Yeah, a scriba, which is, I'm sure many of us are familiar with it, the famous or infamous Ninth Circuit decision that essentially said the employee can decide if they don't want FMLA to apply, that we could envision, the court said, some circumstances when the employee does not have to use FMLA when it otherwise would apply. You know, of course, we've got DOL opinion letters from the previous year that specifically say a scriba is no good. We're not going to follow it as an agency, and we encourage you not to follow it either. So you do run into that scriba situation. You're absolutely right. You know, you could have a situation where everyone's trying to be benevolent here. Okay, you know, I've got to furlough a ton of people right now. If you're telling me that you need leave, I'll furlough you, but you're absolutely right. You don't then have job protection coming out of that furlough. So you could decide that, you know, Eric I realize now he wasn't cutting it for us. And so I've got to let go a certain number of employees. I'm going to let Eric go. So as opposed to being on leave and your employee may, although it may not always be the case, your employer may allow you just to take leave rather than putting you on furlough, and you'd have job protection at that point.
And just to make clear to our audience who are like, oh my God, our employees can, what's this, a scriba case? Our employees can reject FMLA leave? No, it's only if you're in the West Coast. So Ninth Circuit, California, Oregon, Washington, Montana, Hawaii, Alaska, Ninth Circuit, that's it. Every other circuit and the DOL, well, not every other circuit, the DOL has basically said that's nuts. So you don't have to follow. All right. We talked a little bit before, Jeff, about the overlap between the FMLA and ADA. And let's focus a little bit more on telecommuting as a reasonable accommodation. So, you know, I've seen, do we spill ink anymore? When people write articles online and blogs, that's not spilling ink. That's just, I've read a lot about, is telecommuting, has it become like a de facto automatic reasonable accommodation going forward? I think the answer is definitely not. But I think the needle has moved. Would you agree with me?
Yeah, I think it has. There are certainly arguments that can be made that this pandemic is a really unusual situation. So it stands on its own. It hasn't changed anything. But boy, so many of us are working from home right now. And there are plenty of arrangements that are working out pretty well. I mean, heck, I'm working at home 100% of the time. And it's going fine. Do I like it? I'd rather be in the office, but that's just me. It's otherwise working quite well. If I wanted to tell my employer, I've been at home for 3, 4, 5 months, maybe by the time this is done, maybe more. And it worked really well. I think that's a pretty effective argument coming out of this pandemic to establish that at least in increasing numbers, that working from home may be reasonable and effective under certainly more circumstances. So I am worried about that. I'm worried about that as one who represents employers, and I advocate for as much flexibility for employers as possible. I do worry about that coming out of the pandemic.
I think what this is going to result in, two things. One is we're going to see extended teleworking, right? Law firms, great example. Put my law firm aside. We're unique. We're the largest distributed law firm in the world. I work from home 24/7. Before the pandemic, after the pandemic, I worked from home. But I think other law firms are going to see that especially if there are childcare issues over the summer and maybe bleeding into the school year, that it makes more sense to allow our attorneys at the very least, and don't operate a law firm, allow certain employees who are effective working from home to continue to work from home, both as a way to keep them happy, but also as a prophylactic measure to deter the spread of COVID-19. The other issue I think you're going to see, and we won't spend too much time on this, is I think unfortunately businesses are realizing that they've found a number of efficiencies or inefficiencies, so to speak, as a result of this COVID-19 pandemic. And while there were a lot of layoffs at the front end, and a lot of those people are going to come back to work. These are people who have to work at the brick and mortar location. I think some of those people aren't going to be coming back, and I think you're going to see more layoffs because companies are realizing that we can run leaner and meaner and be just as effective without our full contingent. So that's depressing news for employees, but I think that's part of the reality. Jeff, what about, we talked a little bit before about return to work, fitness for duty, something we see under the FMLA, and you might require an employee to have the doctor fill it out and certify that they can perform all of the essential functions of the job with or without an accommodation. You give them a job description or some kind of list. How important is that, do you think, going forward with COVID-19? And also on a related subject, employee health self-assessments. So folks who don't have COVID-19, but as part of reopening, the business is saying, look, we want you each day to take your temperature, to fill out this little questionnaire. Maybe it's on an app, maybe you log into the intranet, and you certify that you don't have the fever, you don't have any symptoms, and then you can come into work. What do you think about all of this documentation and certification?
Yeah, I would say that some of it is necessary. Let's make clear at the outset, none of this is ever going to be perfect. The temperature checks, plenty of errors there. We know that some of this testing is at error. Heck, we're seeing some data just over the past 24 hours. The tests that the White House is using right now is now suspect. Antibody tests. Just over the past week, there's somewhere over 100 commercialized antibody tests that are available on the market. About 12-ish have actually been approved and authorized by the FDA. So that means a whole host of them have not been. And they're showing already in early studies that many of these are giving out false positives. So it's a mess right now when it comes to testing. And we ultimately are going to have to, for some of this, going to have to rely on our employees. So that's why I'm first and foremost recommending to my clients that I find the best measure right now as you are returning employees to work is the health assessment. Is it perfect? No. Can employees lie? Yes. But it is a measure that we can take to help us give us, at the time, as good of a snapshot as possible as to who might be at risk of having either influenza or COVID-19 and to keep them separate from the workplace. It's going to be the quickest, the most efficient. Certainly temperature checks are efficient as well for the most part, but it's going to give us the best snapshot right now. So I'm encouraging, we certainly have the right to do it under EEOC guidance right now. So until they tell us otherwise, we certainly can ask questions of our employees. I recommend it on a daily basis. Some of you just simply can't do that. I recognize that. But we want to do it as often as we can. I'm recommending to my clients that can do it, that they do it on a daily basis before the employee comes into work. If you can do it through an app, like you mentioned, Eric, if you can do it through a website where you answer the questions, and maybe you get a badge that allows you into work that day. I'm seeing that pop up from some of my larger clients. I think that's excellent. It's very efficient. It's seamless. It allows you quickly in the door when you get to work, so you're not facing the lineup of people going in to have this done. So I think it's as effective as we can make it right now. And it also, on the flip side, it's something that we can now show down the road when we are potentially facing litigation over unsafe workplaces. You opened up your workplace when it was unsafe. Here's one measure that we can use. Look, we took self-assessments on a daily basis or on a regular basis as one measure among many to keep our workplace safe. So, those are the kinds of things that I want to have in my arsenal when I'm defending employers. Temperature checks are they're increasingly the norm, but we all know those are imperfect. It's just another data point. It's another data point that we can use.
Yeah, which summer associate at Littler is going to be tapped with donning the PPE and doing the temperature checks? Anyway, well, one other thing before we take some questions, and this will dovetail into the questions, because inevitably I get these types of questions. The skeptical HR professional thinks that maybe employees might be abusing the system a little bit and being a little bit too opportunistic. So to the extent that there is FMLA abuse going on in connection with COVID-19, I'm thinking there are a couple things you can do. One is you do have the certification at your disposal, and if someone, if I'm trying to think of a situation where you need to recert, but maybe you could. I mean, if the original certification's for a couple weeks or something like that, maybe you need to recert. It's not really going to be an intermittent leave type recert situation where someone's, due to be out with COVID for like 2 episodes a month lasting 2 hours each. I mean, that's not going to come up here. But you certainly have the certification at your disposal. You do have your call out. I mean, you can certainly follow your call out rules. I mean, you're not going to make someone call out every day if the doctor says they're out for 2 weeks, but if it's something shorter term, you can certainly use call outs at your disposal. Training your supervisors. I mean, this is unique territory here. There's training your supervisors to at least understand what their role is here in enforcing call-out procedures, documenting employees who can't come in because of COVID-19, and training them kind of to ask, why aren't you coming in today again? And not necessarily just taking someone's word on it. That's another one. What am I missing? We're not quite there yet where we're rife with COVID-19 FMLA abuse, but I'm just trying to think ahead as to what some of the things that might pop up would be.
Yeah, well, social media is going to cut both ways for us. I think many of us have a little more time on our hands. If we're not employment attorneys or HR professionals, you tend to have a little more time on your hands during this pandemic. You're in increasing numbers working from home. So I'm certainly seeing a lot more social media. I'm seeing a lot more Facebook posts, a lot more videos of what we're doing around the house, of what we're doing out in the front yard. On one hand, do you have an opportunity to catch your employee? And look, I'm an employer attorney. I don't want to come off heartless in saying this, but you are going to come across situations where there seems to be abuse going on. And on occasion, you're going to use social media to your advantage, so long as it's lawful to do so, so long as you have someone's permission to look at it. And you're going to see some activities from your employees on social media that seems to be inconsistent with their need for leave, especially if we're talking classic FMLA or paid sick leave where someone is ill or a family member is ill. So you may have some additional opportunities on social media if that's used effectively. It also is going to cut against you in a way that I think because we have shelter-in-place orders in place now, most of those videos are going to be shot around the home. They're going to be shot in the front yard. And so it's not going to be the, I caught you on Facebook on the Mexican beach vacation or fishing 5 states away, or rather it's going to be in your front yard. So it's going to also cut against findings of misuse of leave, because the employee is going to say, look, I took 5 minutes to play ball in the yard with my kid and we videotaped it. So it's going to cut both ways, but it'll be interesting. We're certainly going to see some court cases dealing with social media during the pandemic.
Yeah, and we're not suggesting that HR has the time to go on social media to monitor employees, but usually in these situations, it's the coworkers, the friends who no longer become friends when they narc out their Facebook friends for doing stuff that seems inconsistent with their FMLA. All right. I think I kept this thing open till about 1:15. I don't know. Jeff, you good till about 1:15?
Sure. Yeah.
All right. Let's see how.
Do we have a lot of questions? I've not looked.
All right. I'm going to take some questions from the group that like literally we have some questions going on in the chat. And there's one that I saw that you and I and John Hyman and others have debated ad nauseam. It is the concurrent leave question. You ready?
All
Here
right.
it is.
Let's talk about it.
So Lisa Berg asks, have you changed your position regarding the employer's right to require employees' paid leave to run concurrently with FMLA, EFMLA for weeks 3 through 12? All right. That was, I don't know if I misread that, but basically, here's the question. During weeks 3 through 12 of FMLA, of EFMLA, expanded FMLA, the DOL has said that employers can run paid leave that would otherwise be available for those purposes concurrently. So the question is, when you run leave concurrently with EFMLA during weeks 3 through 12, how much are you paying the employee each day? So the debate was, I guess.
Thank you, Lisa Berg, for asking this question.
Yeah. So there are basically 3 options. One is 2/3 pay, which is what you'd get up to $200 a day, which is what the EFMLA prescribes. And we know that's not the answer because paid leave runs concurrently. So we knock that out. So that leaves 2 other options. Is it 100% of the employee's pay, i.e. a day off, or is it 166% of the employee's pay, a day off plus the 2/3? For a while, I was team 166. And but what I did, because I'm a nerd and because I, have perhaps I don't have better things to do, or maybe I'm a glutton for punishment, is I called 6 different DOL field offices and asked this question. And
Nerd.
and not one of them said 166%. And I didn't love their answers. I caught some of them flat-footed, and I don't want to call anyone out in particular. But I did get the best response, and I think the most reasonable response I got was from, and I forget which office it was, person who said, look, here's what you do. You give 100% pay. You take off a PTO day. So that is your running concurrently. And you take a 2/3 tax credit from the IRS. That's it. So when I came back and asked, well, there's also something in the DOL regulations that talks about an employer and employee agreement to top off someone's pay, right? That has to mean something different. And she said, well, it does mean something different. And that's a situation in which an employee might have paid time off available to them. under an employer's policy that isn't otherwise suitable for EFMLA purposes. So let's assume it's a sick day, a bereavement day. Oh, Tara Brown, what are you doing here? Could you mute yourself, please? Hold on. Sorry, folks. We were going along so well for a while. Bear with me 1 second, folks. All right. Sorry about that, folks. So what I was saying is that if an employee has, let's say, a day of some sick pay for themselves banked away with the employer, or bereavement leave, the employer and employee can agree to apply that, okay, to top someone off from 2/3 to a full day. All right. So in sum, 100% if you run it concurrently, not 166, and the employer-employee agreement has to do with other forms of leave that wouldn't otherwise apply during for EFMLA. At least that's what I was told. How's that sound?
Yeah, I think that's what well, in short, that's what I'm counseling clients to do at this point. You and I have talked about this, and I think this 166 is certainly a reasonable reading of the FAQs that most recently came out. And keep in mind, let's not belabor the point, but this has been a mess. This whole topic has been a mess. I know that DOL had days and weeks to put regulations together and FAQs together. This is no small task on their part. And I think they've generally done a pretty good job of sharing information and getting information out to us to help us administer this new law. But this particular topic has been a bit of a mess in terms of what the original reg said. Then they deleted a portion of that reg. Then they issued FAQs that I just wish they had clarified better for us. You know, you've several times have asked for DOL to give us some examples on this topic, and I couldn't agree more. It really would be helpful to get some examples from the DOL so that we knew exactly how we should be administering this, because this is one of the big questions that employers have. How do you run FFCRA along with employer provided paid leave? And it's not easy.
Someone asked, would your answer to this question change if the employer provided unlimited PTO, so it's not accrued leave? I just want to ask, I'm going to modify that question a bit. Jeff, do you know of any employers that are using unlimited PTO anymore?
You know, actually, a fair number. I mean, it's not some minimal number anymore. It's an increasing ask from us, and unlimited PTO, that may veer us off on a different topic, but just be very careful before you are implementing an unlimited PTO policy.
Mm-hmm. Here's another question. Well, let's take a question that was submitted in advance. Okay, these are the ones we've vetted and screened, and these are the ones I have deemed softballs. If a state employer has certain locations where the employees are not eligible for regular classic FMLA due to the 5075 rule, are those employees eligible to take emergency FMLA, expanded FMLA, whatever we're calling it, because the employer has under 500 employees company-wide? That's an easy one. The answer is yes. Yep. And bonus point, make sure that your FMLA policies include the 5075 rule. Otherwise, you end up like what the city of Kalamazoo when they had their handbook that without the 5075 rule, and they were. This is what you get, folks, when you get like two wonks that all they do is FMLA. They can just cite.
Love Kalamazoo, though, right? Those of you who've been to Kalamazoo, it's a special place. Yeah, I even had my Western Michigan. I got Saugatuck, Michigan on me today.
Nice.
You can't beat the west side of Michigan, and especially in the summertime. There isn't a finer place out there.
Nice. All right, next question. An employee has a chronic health condition for which they are requesting time off to be safe from the virus. This sounds very hypothetical. He or she has used his 80 hours of FFCRA leave and is requesting 2 more weeks off. So let's recap. Employee has a chronic health condition, requesting time off to be safe from the virus. They've already used their 80 hours of FFCRA or EPSL. They want 2 more weeks. Does this qualify as FMLA?
So that's the Santiago case that I talked about earlier. So on its face, I don't think you necessarily have to, but if they provide medical documentation, now we're in a potential classic FMLA situation. FFCRA is behind us because we've provided 2 weeks of paid sick leave, potentially. Let's assume that we have. Now we're just in a regular FMLA situation. Now I think we're back at Santiago. Do you need to provide leave simply because they're worried and they want to stay at home? No, and the DOL has said as much, but they come to you with a medical certification form that looks like what we saw in the Santiago case, that this person has this condition. We are advising them to stay off work because of a concern about exacerbation of their serious health condition. Now I think we're in a different we're at a different point, and it's quite possible that FMLA might apply in that kind of situation.
Yeah, I'm giving out FMLA like notice of rights and certifications like candy. If there's any doubt, it's like, here, take it, get it out. They don't have to say the letters FMLA. If it smacks of anything that resembles a serious health condition, and immunocompromised status certainly sounds like that to me, I'm giving it. So here, fill it. Next question that was submitted in advance. An employee has already used all of his or her FMLA and is not eligible again until October 2020. Now wants to take 12 weeks of leave for childcare under reason number 5 for the FFCRA, which is also the expanded family medical leave reason. Would they be eligible for the paid sick leave even though they don't have any FMLA available? So can you take the EPSL? You got no EFMLA available. Use that up. Or no FMLA, excuse me, because use that up can get the EPSL. Yeah, right?
Yeah.
Would their jobs still be protected? Not in the same way. You don't have your FMLA or EFMLA rights to job restoration, but you do have the anti-retaliation, anti-discrimination protections of the emergency paid sick leave section of the FFCRA.
Right.
Let's jump back into some of the live chat questions. Let's see. Oh, here's a relatively easy one. EPSL question is: the EPSL is a total of 80 hours and not 80 hours per event, correct?
Correct.
Let's see. What else do we have?
And that too is that may be a bit asymmetrical each week. So think of it as a bucket of 80 hours.
Right.
If you have an employee that works regular schedule 50 hours a week, they get 50 hours the first week. They only get 30 the second week. It's an 80-hour max. It's not as though they can get 100 hours, for instance, out of that.
All right. Oh, here's a clearly hypothetical question for a friend. What sort of protections would an employee with mental health issues, anxiety heightened by COVID, have when being called back into the workplace or to continue working in a shipping or receiving environment. So this becomes more of an ADA question than an FMLA question. I'll take first shot at that. And really, it comes down to having an interactive dialogue with the employee about, what possible reasonable accommodation can the employer provide to enable that individual to perform the essential functions of the job. And the EEOC has updated its guidance on this recently, but just also drawing from experience generally. The key here is being able to, you have to be a qualified individual. The ADA covers a qualified individual with a disability. And the ADA is there to enable them to perform the essential functions of the job with or without accommodation. And if someone comes back to work or can't come back to work, and it's a job where you can't telecommute, right? You work in shipping and receiving. There may not be much, if any, that you can do to accommodate that individual. That individual may not be a qualified individual. Now, could a little bit of extra leave work? Possibly. But is that fear of contracting COVID really going to abate in 2 extra weeks, 3 extra weeks, a month or 2? In some circuits, 7th Circuit, you don't have to give a multi-month leave of absence. That wouldn't be a reasonable accommodation. So that's, there may be other, maybe even light duty, you're still in the workplace. So I question in that situation whether someone like that, and I don't mean that pejoratively, but someone with mental health issues that are exacerbated by COVID who fears returning to the workplace, I don't know that there's going to be much you can do to accommodate that person.
Yeah, that's a tough situation, but it's a very real one. My clients are already dealing with it. We're going to increasingly see that as the case. We're going to find these situations as more and more employers ramp up their operations. You're going to have employees that are fearful of coming back to work. You're going to have at least a handful of them. And at least someone is going to raise the issue of, I've got this fear, I've got this mental health condition that has me fearful about returning to work. A couple of things. This is why it's so critical that you come up with a communication plan for your employees upon their return to work. You have to lay out for them what you've done, what kind of safety measures, what precautions have you taken for their safe arrival back to work. Be specific about what you've done with them. Be specific about what expectations are. And have a conversation first and foremost with your employee about that. So your employee who's fearful about returning, you want to make sure that you've exhausted that part of the conversation to put them at ease as much as possible. You're going to get done with that conversation, and there's going to be plenty of them employees that say, yeah, I still want to take leave from work, or I still don't want to come back. Short of putting them on leave, what can you do for them at the workplace? Is there a way for you to thoughtfully, carefully, respectfully move them away from others, segregate them from others, whilst they can still do their work? You don't have to tell the other employees. You shouldn't tell the other employees. But is there something that you can work out that gets them back in the workplace where they're comfortable enough to be working in a particular area? Think about reassignment, even temporary reassignment. Can we move you into a position where we can still get work from you? You can still be productive. We can count on you, but here's what you're going to do in the short term. And I too, I'm a little pessimistic about leave, extended leave, and whether that's going to help. But I don't think it can hurt that in the next month, keep in mind that hopefully we are in the pandemic of a lifetime. We won't have to deal with this after we see the other side of this. But for the first time in virtually everyone's lifetime, we're going through something that's fairly scary. You know, there's a whole bunch of unknowns here. We don't know what life is going to be like a month from now, 3 months from now. So it's natural that your employees are going to be worried about returning, some of your employees, about returning to work. So giving them another month off may very well work for you. You may not like it, but you could work around it. You know, you're likely not returning 100% of your employees to the workplace. So have patience in those particular situations where the employee has voiced concern to you and is increasingly becoming hostile to coming to work. What are the options that you can offer? I like the idea, if push comes to shove, I like the idea of putting them on a leave of absence, even if it's short term, couple of weeks, a month, so that you can at least show down the road, hey, when we interacted with this person, we gave them the benefit of the doubt. We gave them additional time because we recognized they were worried about coming back to work. But at some point, we had to have people back at work. And at that point, we just simply couldn't offer him or her additional leave. And so we had to terminate employment. I think you're in a much better spot if you can show that you've offered a number of accommodations and you've also given the person additional time off. I mean, I think that puts you in a very defensible position down the road.
All right. Well, we're getting pretty close to 1:15. I'm going to do one more question. Let's see if we can answer this one quickly. Hypothetically, if an employee who does not actually exist turned in an FMLA certification that states that the person is not impaired, able to work, but is hypothetically told nonetheless to stay home by their medical provider. All right? So the certification says that this person has basically no serious health condition.
Wow.
The provider wants them to stay home anyway. Would that qualify under traditional FMLA? No.
No, and I'm happy to defend that decision.
Yeah. All right, folks. Well, thank you very much for tuning in. We
Thanks,
appreciate
everyone.
showing up today. Let us know by the way, let us know in the chat before you log off. Let us know in the chat. Do you like Zoom better than Facebook Live? Do you like Facebook Live better than Zoom? Let us know. I'll take that into account when doing this going forward. I want to thank my extra special guest, Jeff Nowak. Jeff, is there anything you want to plug today?
No, just you did it for me, Eric. I welcome everyone to reach out through LinkedIn. Let's stay connected. I find, and I think you do too, I mean, LinkedIn is the best I've found to kind of have authentic conversations with people about these HR issues. And so I encourage the continued discussion there. And thanks for the plug on my blog, FMLAinsights.com. I welcome everyone to subscribe there, in addition to your blog, of course.
Thank you very much. Thank you very much. All right, folks. Well, thank you very much for tuning in. If there's anything you missed because we went too quickly today, I am recording this. I did remember to hit the record button. Yeah, I did. So I'm going to post this later today on the Employer Handbook YouTube channel. I will also post links to the recording in the blog on Monday. Everyone, this is the standard departing greeting. Everyone stay safe, stay healthy, stay well, and have a great weekend. And hey, Jeff, double doink. Talk to you later. Bye-bye.
Thanks for having me, buddy.
Bye.